Hello everyone, how are you all? This is CMA Shukla, and I know it's been such a long time we are not in touch and I'm unable to upload any lectures related to any class, either it's foundation, inter or final. So today it is a revisionary class for CMA final student, and today's topic is inspection, inquiry and investigation, which consists of around 3 to 6 marks in your examination, and section 206 to 229. So inspection, inquiry and investigation consists of section 206 to 229, and this is a chart of that sections which is provided under the sections. Section 206 talk about power to demand informations. Section 207 conduct of inspection and inquiry. Section 208 inspection report. Section 209 search and seizure. Section 210 investigation into the affair of company. Section 211 establishment of SFIO, means the SFIO is section 211, this is your SFIO, and your section 212 investigation by SFIO. So first of all, I just want to give you the brief about SFIO. It is serious fraud investigation office. Section 212 investigation by SFIO. Section 213 investigation into company's affair in other cases. Section 214 security deposits. 215 firm, body corporate not to appoint as inspector. 216 investigation of ownership. 217 procedure and power of inspector while conducting inspection, inquiry and investigation. Section 218 protection of employee during investigation. Section 219 investigation into affair of related company. Section 220 search and seizure for investigation. Section 221 freezing of asset of the company. Section 222 imposition of restriction upon such securities. 223 formalities of inspector report. 224 action after report of inspector. Section 225 express of investigation. 226 voluntary wind up of company not to stop an investigation. 227 legal advisory and bankers not to disclose certain information. 228 investigation of foreign company. The last section is 229 penalty for furnishing false statement, mutilation, destruction of documents. So this is all the section which we are going to discuss under inspection, inquiry and investigation. So before starting the sections, I just want to give a brief about the exam question to my dear students. This is the attempt, this is the marks, and this is the question which is asked in that relevant attempt. So I'm talking about June 11. June 11, this chapter consists of 4 marks, and the question is list out kind of investigation under different sections. December 12, 4 mark, search and seizure not to be done by ROC. June 14, 3 marks, protection of employees during investigation. December 16, 5 marks, duties and power of inspector. June 17, 6 marks, again duties of inspector. December 17, 6 marks, 101 member out of 5 member approached CG for investigation. CG may or may not accept. You have to give answer. June 18, 4 mark, inquiry by the registrar, section 206. December 18, decide the liability of person under investigation, inquiry and inspection. That is, a person who is required to make statement during the course of investigation pending against its company is a party to the manipulation of its company. Document related to transfer of securities and warning of holder in the ROC. And the next second question is, employee publicized sound financial statement to general public to incite them to purchase shares. Actually, company is in loss. You have to give what is the liability against that party arises once they done the activity. So you already see that 4 mark is the minimum mark and 6 is the highest marks. It means all in all we have average of around 4 to 5 marks from this chapter. My motive to show you the exam question is that once we go through the topic, whenever you go through the topic, you get to know that this topic is important and asked by the ICMAI, and this topic is not that much important, or this topic is not yet asked. So this is the chance. This time we get a question from this topic. That's why I just give the performer, or I can say the picture of questions to you all. Fine. So this is the examination question. You can write on a paper for your help, and this is the brief section chart. How many sections we are going to discuss in this relevant chapter. Fine. So start from section 206. Before starting, I just want to give you the intro about inspection, inquiry and investigation, because it is important, very important to know that what is the meaning of investigation, what is the meaning of inquiry, and what is the meaning of inspection in this relevant chapter. So before starting through the chapter, I just want to go with the definition of few words for you all so that you guys get to know the meaning of these words. So my first word is inspection. I have 3 words. First one is inspection. My second word is inquiry. And my third word is investigation. I have 3 words: inspection, inquiry and investigation. It's moving forward the meaning. First of all, we are going to discuss the meaning. So if I give you a brief meaning of inspection, then inspections means the act of looking at something. This is the act in which you are looking at something very carefully. Or you can say an official visit to a building or organization to check that everything is correct and legal. This is the meaning of inspection. Already inspection means to inspect, to find out carefully, or you can say an official visit to any building or into an organization to check that everything is correct and legal, or you can say as per the law. Now moving forward to inquiry. So first of all, we are going to discuss meaning. So inquiry again means an official process. Inquiry means to inquire, means to ask, means you have an official notice or you have an official right that you can ask anyone related to the respective topic. So this is an official process, or you can say judiciary inquiry, which is given by your judicial process. Judicial inquiry to discover or to find out. To discover or to find the facts about something bad that has happened, which has already happened in the respective organization, and you are going there to inquire for a official or judicial inquiry to discover or to find out. To discover or to find out that relevant fact which inquire or which give you answer that something is bad happened here. So inspection means looking carefully, inquire means approaching carefully, and moving forward to investigation. Now moving forward to investigation. First of all, the meaning. Investigation means the act or process of examine. The act or process of examine any problem, statement, or you can say a crime very carefully, especially to discover the truth. Especially to discover the truth. So, inspection means looking carefully to check everything, that everything is legal or not. Inquiry means to inquire officially or judicially and discover the facts through which you can prove that something bad happened in the organization. And investigation means the act of examine any problem or statement or crime, especially to discover the truth. To find out the truth, we are doing this. So this is the meaning of inspection, inquiry, and investigations. There are slight difference. You guys have to take care of the thing that what is the meaning of inspection, what is the meaning of inquiry, and what is the meaning of investigation while we are discussing section 206 to 229. Okay, see, if I'm talking about purpose, so the purpose of inspection, the purpose of everything. So purpose of investigation is to find out that organization or individual, means employee of the organization, is obeying the law. The purpose is to find out that they are obeying the law or not. Purpose of inquiry is to aim of augmenting knowledge, resolving, if you have any doubt, so resolving the doubt or solving a problem. This is the purpose of inquiry. And last, the purpose of investigation is to gather information, and you can say evidences to support the prosecution to a suspect. Whatever charges is on that suspect, to support that prosecution, you have to gather some information and evidences to prove the crime, to prove this problem in your statements, to find out the error in the financial statement. You have to gather information and evidences. This is the purpose of your investigation. Now, this is the main thing which I have to discuss here. So, now I'm going to start the topic. See, I already told you that section 206 to 229 of Companies Act 2013 deal with inquiry, inspection and investigation. See, inquiry is a basic interrogation. This can be done in both inspection and investigation. Fine. And inspection is verification of compliances, whether all the provisions are being followed or not. People must perform their duties so that they can verify it during inspection. Fine. However, we all know that investigation differ in the purpose, approach and intensity. Interrogation is done in the same manner, but situation changes, objective changes and level become more deep. Inspection is not a negative news because it is a regular practice of company, authority, employee, but investigation is a serious affair because it is only generated when some suspicious activity already done in the business organization and now we want to find out what is the problem. So we are doing that investigation. Fine. Okay. In this company, in this chapter, there are few authorities who has given power to do this inspection, inquiry and investigation. So before moving forward to the section, I just want to give you a brief idea that who is the authority and who has power to inspect or investigate under Companies Act 2013, section 206 to 229. So, see. The powers prescribed by company law means the authorities under company law who have power to inspect and investigate, and the authorities are, there are many authorities. I'm going to give a brief idea about the authorities. So I'm going to draw a chart for you all guys so that you guys understand how many authorities are eligible here. So first of all, our first authority is your ROC. Second is our regional director. Third is central government. Fourth is inspector. Regional director. Third is your central government. Fourth is your inspector. And fifth is your tribunal. There are 5 authorities who have right to do inquiry and investigation and inspection. Your first one is your ROC, second is your regional director, third is your central government, fourth is your inspector, and fifth is your tribunal. So first of all, let's go with ROC. That what is the power of ROC while doing inspection, inquiry and investigation. And after that we are moving forward to our regional director, CG, inspector and our tribunal. Fine. So first of all, ROC. Here, section 206, 207, 208 and 209 has been entertained. And here, ROC has power to demand information, comma, books of account, comma, books and paper, invoices, paper, books, explanation, and also order, first thing, second, and also order search and Caesar, regional director. Section 206, only under section 206, he has power to appoint inspector for inspection purpose. Central government. Section 206, CZ can appoint any authority for inspection. Under section 210, CG can order investigation. Under section 211, CG can establish SFIO. You already know that SFIO, Serious Fraud Investigation Office. Under section 212, CG can transfer cases to SFIO. And under section 224, CG can take appropriate action. Inspector. First point is your section 206. Here, an inspector can demand any information, any books of account, any book and paper while their investigation process. Under section 207, he has all the power as civil court. He has power as civil court. Under section 208, his power to prepare report. Under section 209, power of search and seizure. Search and seizure means to detain, to take the book of account, your information book to himself only. Section 216, verify. He can verify ownership of the company, which type of ownership a company can hold. Fine. And under tribunal, section 213, entertained. Here, tribunal can order investigation. Under section 221, it can freeze. It means the tribunal can freeze asset of the company. Under section 222, tribunal can put any restriction on company while doing the inspection, inquiry and investigation. I hope you guys understand that whenever we are conducting inquiry, inspection and investigation, we have 5 authorities in the form of different sections. We have 5 authorities: your ROC, your regional director, your CG, your inspector and your tribunal. The 5 have right, or we can say power, to prescribe any type of information from the company while conducting any type of investigation, inquiry and inspection. ROC deal with section 206, 7, 8 and 9 and demand any information from the company which is related to books of account and explanation. RD, regional director, deal with 206, where under 206, regional director can appoint inspector for the inspection purpose. CG deal with 206, 10, 11, 12 and 14, where CG can appoint any authority among the all for inspection. Apart from that, he order investigation. Apart from that, he can establish SFIO and transfer any type of case to SFIO. Establish SFIO, transfer cases to SFIO. Along with that, appropriate action also taken by CG if needed. Fine. And if I'm talking about inspector, He under 206, 207, 8, 9 and 16 he has power to demand any type of books of account, and he has equivalent power as like civil court. He have to prepare the report also, and here power of search and seizure means he can seize the books of account whenever needed, and he can verify the ownership, the holding of the companies. And tribunal deal with 213, 221 and 222, where a tribunal can put order of investigation, can freeze the assets of the company, and apart from that, tribunal can restrict or bound the organization affairs for the time being if he needed. Fine. This is the authorities who have power to do so. Now, I already discuss few things which is very important. First of all, this is your section chart. This section is discussed in this class. Apart from that, second point we discussed is the meaning of inspection, the meaning of inquiry, and the meaning of investigation, and what is the difference between all the three, and then the authorities who has power to do all the things, that is inspection, inquiry and investigation. Now we're going to discuss section in sequence. So first of all, the first section we are going to discuss is section number 206 and 207. So first of all, section 206 talk about power to demand information, means who has power to demand information from the respective company to take the inspection, inquiry and investigation process. And section 207 deal with conduct of inspection and inquiry, how inspection and inquiry conduct, and apart from that, who is the authority who has right to conduct this inspection and inquiry, what is the penalty provision if we are not fulfilling the content. So let's discuss the topic now. First of all, section 206 provide powers to registrar, inspector and central government to demand information. Means section 206 provide the three authorities, your registrar, your inspector and CG, to demand any information from the company to take that process of inspection, inquiry and investigation. Second is ROC can demand any document, information or explanation, but it must be demanded in writing. Means our ROC has power to demand any document, any information or any explanation which is helpful in the process of investigation, inquiry and inspection, but it must be demanded in writing only. Then only it is applicable, otherwise not. Next one is, what is this writing means? Writing means on a paper or our social media and fax, web chat is also allowed. So it consists of fax, pager, the pager sort of message, social networking, website and web chat. These all are the options through which you can get that content in writing. Next topic is, if the demand which is demanded by ROC is not given to them, then ROC has to write it in compulsory. Means if the desired information is not given, another written notice is compulsory. by ROC. After that, another notice when given by ROC, and then company does not respond. Company does not respond even after the second notice which is given by ROC. Then ROC can take appropriate action. ROC can take appropriate action such as ordering the inspection. Fine. Now, once it is done, it is duty of company, their respective officers, to furnish all the information demanded by the ROC. Now, this officers include, this is the most important thing, this officer include post officers as well. Means present is already included, but the post is also included, which means if matter is related to a person who has already vacated his office, he will also have to provide necessary information after their vacation also. And if it is found that there is some non-compliances, ROC has to inform company as well as CG, which will take appropriate action. Means if any non-compliances is found out, non-compliances ROC notice, then CG and company. After that, appropriate action can be carried out, and further inspection, inquiry, investigation, winding up, or other appropriate actions has been taken. The last one, if the information which is already provided here, if any of them are not fulfilled by the company or by the officer, in this case, if he is failure to provide information, there is a maximum fine of ₹1 lakh, and in case of repeated offense, ₹500 per day. This is the fine. Section 207, conduct of inspection and inquiry. Conduct of inspection and inquiry, where every director, officer and employee of a company must provide full cooperation to the person doing inspection. You don't have to create any hindrances to that person. Even you have to give full cooperation to that person. If he demand any information, anything which is required by that inspector, you have to provide. Fine. Next, ROC or the person who is doing inspection can perform the following power during the inspection. First, he can take following power. He can take copies of documents if required. Second power, he can place identification marks on the documents verified. The document which is already verified by the inspector, he or she can put any type of verification or identification marks over there. No one is going to bound. He can demand discovery of document, where the document is discovered, who is the writer of the document, from where you can purchase the goods, any type of information which is needed by the inspector to do the inspection, he can ask. So fine, he can summon anyone. Fine, anyone means anyone. He can examine any one oath, and he can carry out inspection of the documents at any place which is suitable for him. There is no any foundation that he has to do each and everything only in the office hour or only in the office only. He has no any restriction and foundation. Fine. And if there is any contravention, that there is a penalty provision, means penalty for contravention. Any type of contravention is done by you or he is facing, then contravention ke liye the penalty will be if he is director who is doing that, any officer of the company who disobey. Fine. What? The direction issued by ROC. Under this section, the director of the or the official shall be punishable with the imprisonment as well as fine. So fine is rupees 25,000 K, means you can say 25,000 to 1 lakh, and the director or the officer who is doing so, imprisonment is up to 1 year. So this is the penalty provision. Fine. So let's revise the section. 206 talk about power of demand. 206 talk about power of demand information, and 207 conduct of inspection inquiry, means who has power to demand information. The registrar have power, the inspector have power, and CG has power. Whenever they want any type of document, information or explanation must be given in writing only, and writing consists of X pager, social networking website and web chat too. If the desired information is not provided to the registrar, inspector and CG, second written notice is compulsory. After that you can take any decision. Fine. So company does not respond again on the second notice. Now ROC has power to take appropriate action, and duty of company officer to furnish all the information which is demanded by the ROC or CG or the inspector. But the thing is, the officer include the post officer as well, who is vacated his office. If required, he has to come and give the information. If you are doing that non-compliances of law, ROC notice the non-compliances to CG also and then company also, and after that appropriate action has been taken. Your inspection, your inquiry and investigation procedure has been taken place, or maybe winding up process also took place. Fine. And the fine will be maximum 1 lakh rupee, and if it is a repeated offense, the your per day fine will be 500 per day. Fine. Now section 207 conduct of inspection and inquiry. Here every director, every officer and employee has to give full cooperation to the person who is doing that inspection. Any question, any type of inquiry, any type of documents, explanation which is required by the inspector, you have to provide them. And after doing this, you must know that ROC as well as the person has respective powers. The power is to identification, put identification mark, to take copies of the document, to demand any document discovery. He can summon them, he can examine any oath, he can carry out inspection and at any place which is suitable for him. And the last one, if you are not fulfilling the condition, then director and officers of the company has to pay penalty. So penalty is 25 to 1 lakh and the imprisonment is up to 1 year. This is all about section 206 and 207. Moving forward, we are going to inspection section number 208. I hope you guys understand the topic as well as if any doubt, please comment in the comment box. I am here to help you all. So now our next section is 208 and 9. Section 208. Section 209. Section 210. So what the section talk about? Section 208 talk about inspection report. Once inspection has been done by the inspector, he has to maintain a report. Section 208 talk about that. If search and seizure required, which type of search and seizure you can conduct, and what is the rules which is related to search and seizure. Section 209 talk about that thing, and 210 is talk about investigation into the affair of the company. Investigation into the affair of the company. So moving forward, section 208. It is related to inspection report. So see, it is very compulsory to that the person doing inspection submit a report, because when you are doing inspection and you are not giving any type of report, how can we know? How can the other person know which type of action is taken by you? What is the reason for that action? So it is very, very important, or you can say it is a compulsion for the inspector to provide the report after their respective investigation. So first point is investigation report is compulsory, that the person who is conducting inspection must submit a report to central government which concluding remark also. What is your remark? Why you do so? What you think about the company's information provided? You have to give a conclusive report. Fine. And the second thing which you have to remember, that report can also suggest. Report means who is prepared that report? Report is prepared by the inspector. Means the inspector can also suggest further investigation if needed. If he thinks so that it is important to do further investigation, so he also refer or suggest the company's further investigation. Fine. Moving forward to section 209. First of all, you know the meaning of search and seizure. So first of all, search means searching the paper or person. Search means finding out the person or paper through which you are going to conduct your inspection. When ROC or inspector is assemble ground, he can go for search and seizure, but for this advance approval of special court is compulsory. Means search and seizure can be done, but before that you have to take approval by special court. Before taking special court approval, you are not eligible to do so. Next, if seizure is done, company can take photocopies and can take notes if required. Means the original document is detained by the inspector, and company have right to take only photocopies of that document which is seized by the respective inspector. Fine. And the most important thing, ma'am, how much time a inspector can seize the document. So the period of seizure must be maximum. It means maximum up to 180 days. which can be extended if required, which can be extended by special code for 180 more days. It means you have 180 plus 180 days if it is given by approval given by special code. Fine. Next, section 210, investigation. See, first of all, the important thing which you have to remember that investigation can take place if it is found necessary, and by whom? By central government. If it is found necessary by central government. Fine. Second, and it is requested by ROC, and more thing, if it is in the favor of public interest. And yes, more thing, company itself demanded the same by special resolution, means majority of the shareholders, or directed by NCLT. These all are the person who can demand investigation into the company affair. Fine. Now, CG can appoint one or more investigation officer to carry out the investigation. Fine. And if investigation is done upon the application of someone, means someone is giving application that I want to check the affair of this respective company, that person has to pay, or you can say a security deposit of rupees 25,000, which is maximum, and if the allegation is correct, the amount is refunded. But if it is not, it is forfeited by the central government. Fine. So someone demanded, then at that time CG may demanded security deposit of maximum rupees 25,000, which shall be refunded if allegation are founded correct. Fine. So, see, the thing which you have to keep in mind. Section 208, inspection report. It is compulsory. You must remember it that it is a compulsory. Definitely it is compulsory. Reason being, if someone is conducting inspection, how can we know that what is the thing which is done by that respective person? We have to find out some report, some concluding statement from that person, so that we can get to know, we stand for the central government, the ROC, the company, that where the company is wrong, where the company is right, what is the thing which must we take care of the company. So for this, the concluding remark report is compulsion, and report can suggest further investigation too if required. Fine. Section 209, search means finding out person or paper. Fine. And it can done by the approval of special court only. Seizure is done whenever seizure is done, company have right to take photocopies of the documents. Fine. And seizure, the maximum period is 180, and which can be extended up to the next 180 if required. Fine. And it definitely it is given, it is approved by the special court too. Section 210, investigation. If it is found necessary by central government, then it is then only it can be done. First thing. Second, it can be requested by ROC too, and it can be requested by the companies by itself also. If demanded by majority of the shareholder, then ROC conduct or central government can conduct the investigation related to affair of the company. Fine. And CG can appoint one or more IO for that. And the most important thing, it is not related to company only. If some other person who is not part of company, who is outsider, but have any doubt, any problem, any type of doubt respective company, he or she can demand that investigation related to the affair of company, and for that someone that he or she has to pay a security deposit of 25,000, which shall be refunded if the allegation which is put by that person is correct. So this is all about section 206, 7, 8, 9 and 10. Now our next topic is 211, and it is important too because it is related to SFIO. So section 201, 211 and 212 both are very important. One is talk about establishment and second is talk about investigation by SFIO. Fine. So section 211 and section 212.